Applying New York law violates a fundamental public policy of the forum state. 2, if there's no reasonable basis for choosing New York, like if the contract has zero connection to New York. Or 3, if there was fraud or mistake in getting agreement to that clause. So party choice is powerful, but not absolute. Now, if there's no express provision, the court uses its state's general approach. Under vested rights, it gets split. Issues about the contract's formation and validity, was there offer and acceptance, consideration, any defenses like fraud, are governed by the law of the place where the contract was executed or made where the last act needed to make it binding happened. But issues about performance, was payment made on time, was delivery sufficient, are there excuses for non-performance, are governed by the law of the place where the contract is supposed to be performed. So you have two different states' laws applying to the same contract. Under the most significant relationship approach for contracts, the court again weighs the policy factors and looks at connecting facts. Where was it negotiated? Signed. Where will it be performed? Where is the subject matter, like goods or land? Where do the parties live or do business? And the restatement second provides helpful default rules for specific contract types, which apply unless another state clearly has a more significant relationship. Contracts about land, law of the situs, where the land is, selling personal property, goods, law of the place of delivery, life insurance, law of the insured's domicile, casualty insurance, car, home, law of the location of the insured risk, loans, law of the place where repayment is due, suretyship, guaranteeing debt, law governing the main debt, transportation contracts, law of the place of departure. These defaults provide a good starting point based on common sense connections. In the governmental interest approach for contracts, same logic as for torts. Forum applies its own law, unless its policies dictate applying another interested state's law after doing the conflict analysis.
Those default rules for the most significant relationship approach are really helpful anchors. Okay, moving from contracts to property, this seems like it should be simpler, tied to physical location, right?
Largely, yes. Property rules often follow the location. For real property land, buildings, things fixed to land, the rule is almost universally the law of the state where the property is located. The lex situs, as lawyers say. Makes sense, right? Land doesn't move, and the local government has the strongest interest in controlling it. So, issues about title, mortgages, inheritance of land, all governed by the law of the situs. For personal property, things that are movable, it's a bit more complex because it can move. For tangible personal property, cars, jewelry, goods, if it's a sale, the Uniform Commercial Code, UCC, likely governs in most states. Otherwise, the general rule points to the law of the state where the property was physically located at the time of the relevant transaction or event. For intangible personal property, like stocks, bank accounts, debts, patents, it often depends. Maybe the law of the state where the intangible right was created. Or for a debt, where the debtor is domiciled. It's less tied to a physical spot.
Situs for land, location for tangible stuff, maybe creation place for intangibles. Got it. How about inheritance? Wills and estates often cross state lines.
Yes, inheritance rules need clarity. First, if the person making the will, the testator, included a choice of law clause in the will itself, interpret this will under Florida law. Courts usually honor that for interpreting the will's meaning and effect. Testator's intent rules. For the validity of the will itself, was it signed correctly? Witnesses. Most states have flexible rules. A will is usually valid if it complies with the law of the place where it was executed, or the testator's domicile at death, or the testator's domicile when they signed it, or even the place where the testator had an abode or was national at death. Lots of options to uphold the will if possible. When it comes to distributing the property, personal property, money, stocks, cars, is governed by the law of the deceased person's domicile at the time of death. Personal property follows the person. Real property, land, buildings, consistent with our property rule, is governed by the law of the situs where the property is located.
Personal property follows the person, domicile at death. Real property follows the location, situs. Clear distinction. Okay, what about corporations again? We know domicile is a state of incorporation. Does that state's law govern everything about the corporation?
Not everything, but it governs most things related to the corporation's internal affairs. This is the internal affairs doctrine. Issues like the rights and duties of shareholders, directors, and officers, rules for corporate governance, stock issuance, declaring dividends, these are typically governed by the law of the state of incorporation. It provides a single, predictable set of rules for managing the company's internal structure and relationships, no matter where it operates or where its shareholders live. It avoids absolute chaos.
That makes sense. One set of rules for internal governance is crucial. Okay, last specific area, family law. This is huge: marriage, divorce, kids, property often involving people moving between states.
Definitely a hotbed for conflicts issues. Let's break it down. Marriage validity. Generally, a marriage is valid everywhere if it was validly celebrated in the place where the marriage ceremony took place. The place of celebration rule. Get married legally in Vegas, you're generally married everywhere. But there's that key exception. If the marriage violates a strong prohibitory rule, not just a regulation like needing a license, but a fundamental ban like on bigamy or a certain close relatives marrying, of the domicile of one of the parties, and the parties immediately return to that state to live after getting married elsewhere, then that home state can declare the marriage void. It's an anti-evasion rule. Divorce grounds. The legal reasons you need to get a divorce, fault, no fault, waiting periods, are determined by the law of the plaintiff's domicile, the state where the person filing for divorce legally lives. Marital property. This gets tricky and depends on when the property was acquired. Property owned before the marriage. Real property, Cetus law. Personal property law, the owner's domicile at the time of marriage. Property acquired during the marriage. Real property, Cetus law. Personal property law of the couple's domicile at the time the property was acquired. So if a couple lived in California, a community property state, and bought stock, then moved to New York, a separate property state, California law might still determine that the stock is community property upon divorce. The cure gets fixed at acquisition. Hashtag defenses against application of foreign law.
Wow, family law really highlights how domicile and timing matter. Okay, so even if a court goes through all this analysis and decides, yep, state X's law applies here, are there still ways for a party to argue, hold on, court, you shouldn't apply that law, like escape hatches?
Yes. Even after the choice of law analysis points to another state's law, there are a few key defenses that can prevent its application. Think of them as final barriers. First, the big one, procedural versus substantive. We touched on this, but it's crucial here. The forum court always applies its own procedural laws. Always. So even if California substantive law applies to the car accident claim, the Texas court hearing the case will use Texas rules for things like the statute of limitations, when the suit had to be filed, rules of evidence, how discovery works, burden of proof. The forum controls its own courtroom machinery. Second, the public policy defense. A forum court may refuse to apply a foreign law, even if choice of law rules point to it, if applying that law would violate a fundamental, deeply held public policy of the forum state. It has to be something really offensive to the forum's core values, not just a minor difference in law, like maybe enforcing a contract for something considered grossly immoral or illegal in the forum state, tie bar, but that's a safety valve. Third, the penal law defense. Forum states will not enforce the penal laws of another state. Penal laws are things like criminal statutes, or laws designed primarily to punish wrongdoing, rather than compensate an injured party. Think fines payable to the state, or imprisonment. One state won't act as the jailer or tax collector for another state's criminal code.
Procedural rules are always local. Public policy can block offensive foreign laws, and no enforcing other states' criminal penalties.
Got it. One last practical point here. How does the judge even know what the law is in another state? Do lawyers have to bring in experts to testify about it?
Thankfully, no, usually not. That would be incredibly inefficient. Most states and the federal courts allow judges to take judicial notice of the laws of other U.S. states and federal law. This means the judge can simply be informed of the relevant statute or case law from the other state, usually by the lawyer submitting briefs, and then apply it as law, just like they would their own state's law. They don't need formal proof like they would for a contested fact. Federal courts are required to take judicial notice of the laws of all states. It streamlines the process considerably. The judge doesn't need to be an expert in all 50 states' laws. They just need to be able to look it up and apply it once it's brought to their attention. Okay, perfect. So we've navigated the maze of choosing which law applies before a decision. Now let's flip to the other side. What happens after a court makes a final decision, a judgment? Say you win your case in California, get a judgment for $100,000. Can you just take that California judgment paper over to New York, where the defendant has assets, and start collecting? Is a win in one state automatically a win everywhere?
That's where the other side of the full faith and credit clause comes in FFC for judgments. And the general answer is yes. A valid win in one state is treated as a win everywhere else within the U.S. The core principle is fundamental. If a judgment is validly rendered by a court that had proper jurisdiction over the parties and the subject matter, and the parties got proper notice and a fair chance to be heard, then that judgment must get the same effect, the same respect, the same enforceability in sister states as it has in the state where it was rendered. Think of it using that flowchart logic. Did the first court have jurisdiction? Yes. Was the judgment final? Yes. Was it on the merits of the case? Yes. If all yes, then generally, full faith and credit is required. It prevents people from relitigating the same case over and over in different states. Finality is key. Now, there are a few narrow defenses or exceptions. We mentioned penal judgments earlier. Those aren't entitled to FFC. And some very limited equitable defenses might apply, like if the judgment was obtained through extrinsic fraud, fraud that prevented the defendant from even having their day in court, but that's rare. What if you have inconsistent judgments? Say, State A rules for plaintiff, but later State B rules for defendant on the same issue. The general rule is the last-in-time rule. Courts should recognize the most recent valid judgment. And crucially, a state must recognize another state's judgment, even if the enforcing court thinks the first court made a mistake of fact or law. Your remedy for a mistake is to appeal in the rendering state's court system, not to collaterally attack it when someone tries to enforce it elsewhere. FFC demands respect for the finality of judgments, even flawed ones.
So judgments travel well within the U.S., basically. You honor the sister state's final decision, mistakes and all, unless there was a major jurisdictional flaw or it's penal. What about federal court judgments? How do they fit into this state-to-state recognition picture?
They fit in pretty seamlessly. It's a two-way street, federal to state. State courts must give full faith and credit to judgments from federal courts, state to federal. If a state court issues a judgment, federal courts must also give it full faith and credit. And specifically, if a federal court sitting in diversity issues a judgment, a state court later looking at that judgment must give it the same res judicata or claim preclusive effect that it would be given by the courts of the state where the federal court sat. Remember Claxon for choice of law. This is similar for preclusion. The federal judgment's preclusive power is measured by the law of the state it came from. It ensures consistency.
Okay, so state and federal judgments get mutual respect within the U.S. system. That makes sense. But you hinted earlier, what about judgments from totally different countries, like a judgment from Germany or Japan? Is that automatically honored here under FFC?
No, absolutely not. That's a critical distinction. Judgments from foreign countries are not entitled to full faith and credit under the U.S. Constitution. FFC only applies between U.S. states and territories. Recognition of foreign country judgments happens, if at all, as a matter of comity. Comity is basically discretionary respect between courts of different sovereign nations. A U.S. court might recognize and enforce a foreign judgment if it finds the foreign court had proper jurisdiction, the proceedings were fair, and enforcing it doesn't violate U.S. public policy. But it's not automatic. To bring some uniformity to this, many U.S. states have adopted the Uniform Foreign Money Judgments Recognition Act, UFMJRA, or similar statutes. This act provides clearer rules for when state courts should recognize foreign judgments that grant or deny specific sums of money. But even this act has important exclusions. It typically doesn't cover foreign judgments for taxes, fines or other penalties, or judgments for family support like alimony or child support. Those areas are often seen as uniquely governmental or subject to ongoing modification, so U.S. courts usually handle them under different rules or refuse enforcement altogether. So a French judgment for a commercial debt might be recognized under the act, but a French tax judgment probably won't be.
That's a really important distinction. FFC is domestic, comity is international and discretionary, may be guided by UFMJRA for money judgments, but not things like taxes or support. Very clear. Okay, let's wrap this chapter with recognition of divorce judgments. You mentioned family law earlier, and divorce decrees definitely cross state lines frequently. How does FFC apply here?
Divorce judgments are a prime example where FFC gets tested. The basic rule is, a divorce decree from another state is entitled to full faith and credit if 1. The original state court had jurisdiction to grant the divorce, and 2. The decree is valid in that original state. The key here often boils down to jurisdiction, specifically distinguishing between bilateral divorce and ex parte divorce. A bilateral divorce is the gold standard. This happens when the court granting the divorce has personal jurisdiction over both spouses. Maybe both appeared, or one filed and the other was properly served within the state and responded, and at least one spouse was domiciled in that state. In a bilateral divorce, the divorce decree itself, plus all the related orders, property division, alimony, spousal support, child custody, are all entitled to full faith and credit in other states. Both sides had their full day in court on all issues. An ex parte divorce, however, is different. This happens when the court has jurisdiction over only one spouse, the one filing who is domiciled there, but not the other. Maybe the other spouse lives out of state and never appeared. In this situation, the divorce decree itself, the part that legally dissolves the marriage, is entitled to FFC. So the parties are legally single everywhere. But, and this is the crucial part, the collateral orders concerning money or kids, property division, alimony, child support, custody, are not entitled to FFC based solely on the ex parte decree. Why? Because the court didn't have personal jurisdiction over the absent spouse, so it can't impose financial obligations or custody arrangements on them. Those economic and custody issues have to be sorted out later in a court that does have personal jurisdiction over both parties. And for child custody specifically, the situation is largely governed now by the Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA, which nearly all states have adopted. Under the UCCJEA, the court in the child's home state, generally where the child has lived for the last 6 months, has priority jurisdiction to make the initial custody determination. And critically, all other states must give full faith and credit to that initial custody order. The UCCJEA aims to prevent parents from moving states to find a more favorable court, forum shopping for custody. While custody orders can sometimes be modified later by another state under specific circumstances, like if everyone moves out of the original state, the UCCJEA creates a strong system for recognizing and enforcing the primary custody order across state lines.
Okay, this has been incredibly thorough. We've gone from domicile through the thicket of choice of law and now into recognizing judgments. It's a lot. To really make this practical, especially for someone facing the bar exam, let's try to synthesize this. How do you spot these issues in a fact pattern, and then what's the systematic approach to tackling them? A quick roadmap.
Excellent idea. Having a framework is key. Broadly, conflict of laws problems fall into those two big buckets: choice of law or recognition of judgments. Figuring out which bucket you're in is step one. For choice of law, spotting it. Look for facts involving two or more states. Are the parties from different states? Do key events happen in different states? Does the fact pattern mention the laws of multiple states, maybe highlighting a difference or conflict between them? If yes to any of these, you're likely dealing with a choice of law issue. Approaching it. 1. Quick check. Does the court have jurisdiction and proper venue? Gotta have that first. 2. Pinpoint the conflict. What specific legal issue has conflicting laws? E.g., State A allows punitive damages, State D doesn't. Which law applies to damages? 3. Characterize the substantive area. Is it torts, contracts, property, family law? This guides rule selection. 4. Determine the approach. Which choice of law approach does the forum state use? Vested rights, most significant relationship, governmental interest. The question usually tells you. If not, briefly discuss the likely options. 5. Apply the facts. Methodically apply the facts of the problem to the relevant approach and its specific rules or factors to reach a conclusion on which state's law governs that specific issue. Show your work.
Perfect. That's a solid checklist for choice of law. Now, what about the other bucket, recognition of judgments?
For recognition of judgments, spotting it. Is a party trying to enforce or get recognition for a judgment that was already decided in a different court system, another U.S. state, federal court, or a foreign country? That's your clue. Approaching it. 1. FFC requirements for U.S. judgments. Was the judgment from a court with proper jurisdiction? Is it a final judgment? Was it decided on the merits? If yes to all three, FFC is generally mandatory. 2. Preclusive effect. If FFC applies, the judgment gets the same res judicata, claim preclusion, and collateral estoppel issue preclusion effect in the enforcing state as in the rendering state. 3. Foreign country judgment. Remember, no FFC. Recognition is discretionary, finality, possibly guided by the UFMJRA for money judgments, but excluding taxes, support, penalties. For divorce judgment, analyze carefully. Was it bilateral jurisdiction over both spouses? If yes, the decree, A&D, collateral issues, property, support, custody get FFC. Was it ex parte jurisdiction over only one? If yes, only the divorce decree itself gets FFC. Collateral issues need separate resolution in a court with jurisdiction over both. Child custody, think UCCJEA. Initial determination by the home state gets FFC everywhere. Modification is limited.
That clear framework, breaking it down into spotting the issue and then hitting the key steps for analysis, really helps cut through the complexity, gives you a definite roadmap for any problem you face. Hashtag outro. So wrapping this all up, what does this mean for you, our listener? We've taken a pretty deep dive into conflict of laws today. We started with the basics, figuring out where someone legally lives with domicile. Then we navigated the tricky paths of choosing which state's law applies when things cross borders. And finally, we looked at how judgments themselves travel across state lines. It's a really fundamental area, quietly underpins so much of our interconnected legal system, especially here in the U.S. And for the bar exam, honestly, getting comfortable with this gives you a huge leg up on those complex integrated questions. It can turn a subject that feels intimidating into, well, a place where you can really shine.
And just to leave you with a final thought connecting this to the bigger picture, think about how things like global digital commerce, where maybe the location of a transaction is everywhere and nowhere simultaneously, or even wilder future stuff like legal issues in space. How might these developments challenge the very principles we've discussed? Domicile in cyberspace. Choice of law for AI-driven torts happening across borders. Recognition of judgments from, I don't know, a Martian court. It sounds like science fiction, maybe, but it raises a serious question. Will our current frameworks developed for a world of clear physical boundaries be enough? Or will we need entirely new legal concepts, new treaties, new ways of thinking to handle the conflicts of the future? It's a field that's surprisingly dynamic.
That's a fantastic point. It really drives home that law isn't static, it's constantly adapting or trying to. Well, thank you so much for joining us on this deep dive into the world of conflict of laws. We really hope this has shed light on what can feel like a tangled web and given you both the confidence and the curiosity to tackle it. Keep exploring, keep asking those tough questions, and keep making those surprising connections between different areas of law. We'll catch you on the next deep dive.